National Legal Advisor of the Committee for the Defense of Human Rights, Henry Ekene, for more on this development. Thank you for joining us, Mr. Ekene, on the news. Interesting development from Rivers. Two different houses of assembly sitting simultaneously. How do we interpret the ruling from the Court of Appeal?
Thank you very much for having me. It's my pleasure. I apologize, really. But it's unfortunate that we have this kind of embarrassment in Rivers State. But I dare say that the Constitution of the Federal Republic of Nigeria, 1999, precisely Section 90, established only one House of Assembly for each of the 36 states of the Federal Republic of Nigeria. So we cannot have two houses of assembly for Rivers State. That's an aberration and then unimaginable for the provisions of the Constitution. The most or the worst we could have is probably individuals contending for the position of the House of Assembly Speaker. And that's, I think, what we have. And the controversies have raged on since October last year and precisely on the 11th of December 2023. I think it's only in a country where impunity reigns over the rule of law or where citizens appear to be clouded by probably political interests and leaning and jettisoning the fundamental provisions of their constitution. Otherwise, the proceeding of the House of Assembly in Rivers State on the 11th of December 2023 can never anywhere in the world in a sane democracy be undermined, where 27 members of the Rivers House of Assembly, including Martin Amaewhule and 26 others, defected. Nobody has argued that issue because it's fundamental and it's important to lay the foundation for all of these avoidable and unnecessary crises. It's ridiculous and it's embarrassing. So that 11th of December proceedings has automatically made Martin Amaewhule and the other 26 members no longer members of the Rivers House of Assembly. So the judiciary and interpretations, and now you are asking me what could be the interpretation of the decision of the Court of Appeal, and when judges act as if they are not in the society, and then judges would want to gloss over issues. Even if I'm a lawyer, for me, it's not palatable. But that's why we're here.
It sounded like you are undermining the very institution that you're supposed to represent. Because
apparently I should. Every objective citizen
I would have expected
should.
that as a legal practitioner, you will hold the justices of the court in high esteem, whether you agree with their judgment or not. But a lot has happened since December to this time. I was asking specifically the implication of the Court of Appeal ruling, which nullified the suspension of the 26 members of the House of Assembly. That order was speaking to the issue of jurisdiction, that the state high court did not have the jurisdiction to have decided on that matter.
Yeah. Yes, if I'm still connected.
Yes, you are, Mr. Ekene.
Yes, the decision of the Court of Appeal upon the appeal of Martin Amaewhule and 24 others against the ruling of Honorable Justice Amaewhule with respect to an interlocutory application has got some different interpretation. But I've had the opportunity to see the enrolled order of that judgment of the Court of Appeal. And fundamentally, the jurisdiction of the trial court was the fundamental question before the Court of Appeal, or rather, what appears fundamental in the judgment of the Court of Appeal. And the elementary principle of law is, once the Court of Appeal justice held that that court lacked jurisdiction to even entertain that matter in the first instance, it meant that the order or the ruling that was made upon the application, the interlocutory application, was a nullity. There's no doubt about that. And that is only to the effect of the ruling that Martin Amaewhule and the other members, former members of the House of Assembly, should not parade themselves. That's in no way, in my interpretation, legitimize, or if you like, authenticate the already troubled legitimacy of Martin Amaewhule and the others as members of the Rivers House of Assembly. And the justices of the Court of Appeal were quite aware of that. That's why they held only to the effect that the appropriate court is the Federal High Court.
Exactly the point I was making, Mr. Ekene, that there hasn't been any pronouncement correct me if I'm wrong, there hasn't been any pronouncement by court of competent jurisdiction as to whether or not their defection has affected their position as members of the House. The last time we checked, they even denied ever decamping or leaving the PDP for the APC. But moving forward, talk to us about how you think the parties, the stakeholders involved in this matter can douse the tension. Amaewhule and his colleagues are back at the State Assembly complex, while the other house is also meeting in the state government, in the state government office. What do you consider the way forward here?
Well, I consider the way forward actually, and the only legitimate way forward is the intervention of the judiciary. And these matters are already sub judice before the judiciary. The fundamental question as to the defection and the effect of that defection. See, I heard you talk about their denial. The denial is not what will substantiate the defection. So, but moving forward, I think that the rule of law, which we profess, the Constitution of the Federal Republic of Nigeria is to the effect that Nigeria shall be based on democracy and social justice. And the fundamental principle in democracy is the rule of law. So it's only the way to go is for the law to be respected by all persons, and then let the judiciary be prompt and upright in deciding this matter of the defection of the 27 former members of the Universal House of Assembly. And let me also quickly say one thing with this opportunity, that it is not the court that is required under the Constitution to declare the seat of any person vacant. No. In the first instance, it is the Speaker of the House of Assembly that will do that declaration when a person defects. It is when the defector feels that that declaration is inappropriate or that he has a justification for his defection that he approaches the court. The Constitution did not say that when a legislator defects, then the court is not playing a role at that time.
All right.
I think that the things will mix up everywhere. And then we say the appropriate court is the Federal High Court to determine the issue of the vacancy or cessation of office. That is where an aggrieved person who feels aggrieved by the declaration of a speaker approaches the court. Then the appropriate
I hear you, Mr. Kenny.
I'm afraid doesn't need to go to court.
I'm afraid that's our time. National Legal Advisor of the Committee for Defense of Human Rights, Henry Ekene, thank you so much for talking to us on the news tonight.
Thank you.